Can I be sued? I didn't know the dishwasher was broken. I hand wash my dishes, said the seller. I thought when I purchased the home, I purchased it with a working dishwasher, said the buyer. Does this sound familiar to you? Have you heard stories of this? Who's responsible? Stay tuned and find out. Hi, thanks again for joining me for another hopefully informative video, informative to you hopefully, and watching my channel. So my goal is to provide sellers, whether you're downsizing, whether you're relocating, or even just thinking of selling or moving in the future, beneficial advice. And this advice is also good for buyers, of course. So, drum roll, here we go. Who fills out the seller's disclosure? The seller, of course. This applies to sales, but also transfers by exchange, land contracts, lease with option to purchase, and transfers of stock interest in a residential co-op. Okay, this does not include vacant land or commercial properties, a commercial deal. Of course, they have their own set of disclosures. All right. I am not an attorney. Let me just put it out there. This is just in generalities, okay? One common misconception a lot of sellers have is that they say, well, I've never lived in the home, so therefore I'm exempt from filling out this seller's disclosure. Well, you know what? That is not true. Never having occupied the property does not disclude you, does not exempt you from filling that out, all right, from a seller from filling it out, because it's a statutory seller disclosure, and really, if you're the seller, you probably know something about the property, even if you've never lived there. If you're a relation of some sort, you'd been in the home, there are some exceptions for that also. Obviously, there are exceptions for people that, well, let me just say, transfers pursuant to what I would call like a probate court, a foreclosure. What else would I say? A trustee in bankruptcy, transfers, or eminent domain, which is kind of not a good thing. They come and take your property. But basically, if there is an order from a court resulting for a specific performance, obviously it is a court order. You are not involved as a human being, as a person, right? Another exception would be a mortgage. So it's a mortgage company and they're filling it out. It is a foreclosure, and so the lender has it back. They do not need to fill it out, okay? So if there's a person that's in default and the property goes back to it is bought at sheriff's sale and it goes back to the lender, they do not need to fill it out. So there's some other deeds in lieu or some other ones like that. But like I said, I'm not an attorney. You want to check with an attorney if it's something like that. But in a day-to-day transfer of two parties, you have to fill it out. So let me see what else. I think we should talk about transfers between family members. So if you have a transfer and a deed between co-tenants, right? Someone's transferring it to another, a spouse, a child, a grandparent, a grandchild. So if you transfer it between spouses, also in a judgment of divorce, that is not necessary also. So, and it's also not necessary on newly constructed properties. So if you have a newly constructed residential property that's never been occupied, you do not have to fill out a seller's disclosure. Of course, the builder would have their own disclosures with a little bit different. So let me talk a little bit about intentional and innocent misrepresentations. The word misrepresentation has a little connotation when you think about it, but unintentional and misrepresentations on the Seller's Disclosure Act protect the seller against claims for the innocent, which means if the seller made a false statement, but they did not know their statement was false and they had no intention to deceive the buyer, then the seller would not be held liable. So if they misrepresented it and they didn't know about it, then they wouldn't be held liable. But additionally, if the seller had no personal knowledge either of the property defect, then they cannot be held liable. So in that point, but if there's an error, an inaccuracy, or an omission, or that they have actual personal knowledge of this error, inaccuracy, or omission, then the seller can be held liable. So a seller cannot knowingly make a false statement about the property, a fraudulent misrepresentation, or knowingly withhold info about the property that he or she is obligated to provide. All right, that's called silent fraud. all right? So the difference between silent fraud and misrepresentation, okay, they're two different ones. Silent fraud is based on suppressing the material info, meaning not putting it on, like knowing and not putting it on there. So basically they're not saying it, they know it, but they're not saying it, as opposed to affirming the misrepresentation basically means that's different. Our dishwasher is working when they know it's not working. So a silent fraud claim, it also requires the seller to have had a duty to make a disclosure, to answer a question on the seller's disclosure statement. There's specific questions that need to be answered on the seller's disclosure. So they are obligated to provide a truthful answer, right? And especially if the buyer makes a specific inquiry about the property, then they have to give the answer, obviously. So, and again, an example of sellers know that they have recently had water, let's talk about a basement, in the basement, and they answer no on the seller's disclosure regarding the water in the basement. Well, and then the buyer buys the house, goes to closing, and after closing, the buyer discovers the basement walls are leaking, okay? Then they may pursue legal action against the seller, right? But if it was a finished basement and the seller never knew the wall was leaking, then it's tricky, right? So, but they could pursue the seller for either fraudulent misrepresentation or stating that there was no water of evidence or no water in the basement, so that would be silent fraud. But they would purposely have avoided the question that they were obligated to answer, right? It would be silent fraud. But like I said, the challenge is to successfully bring forth a claim of fraudulent misrepresentation or silent fraud. So the buyer must be able to show, they have to prove this, that they reasonably relied on information they received from an independent inspector when they had their inspection done. So it gets a little challenging at this point, but the answer, what I want to tell you is that where do the real estate agents stand in all of this? All right. Well, generally, the listing agent will not be held responsible for misrepresentations made by their seller, okay, their seller client, as long as the agent did not knowingly act in concert, not this kind of concert, act in concert with the seller to violate the terms, the Seller Disclosure Act, in the term meaning in concert. So it means to work together to accomplish a common goal. So be in cahoots. So yeah, I'm not going to put that, but I know there's water in the basement. Say the listing agent knowingly said, well, don't put it down there, and then uploads the forms in the MLS for distribution to prospective buyers, right? And they know the information is false. So in this scenario, both the listing agent along with the seller would be held liable. They would be held liable for fraudulent misrepresentation, okay? So in addition, a listing agent could also be held liable if they make their own purposeful statements or their own purposeful misrepresentations about the property. Say somebody calls them and says, hey, has there ever been water in the basement? And it's saying no on here. And then they say, no, there's never been any water in the basement. Okay, then they could be held liable. So it's really, really, really important to provide transparency, right? So the Seller's Disclosure Act right now has helped provide greater transparency to see through the veil in the disclosure process, right? So it's certainly reduced the potential for disputes, right? And the cost of litigation. Although misunderstandings and misrepresentations of the law can still result in significant legal ramifications, right? For the seller and possibly the buyer and the broker, right? So let me tell you, my friends, the seller's disclosure is an important document, not to be taken lightly, okay, by all parties involved, meaning the buyer, the seller, the agent, the broker. So I hope you found this information insightful and advantageous. And if you feel you found benefit from this, please subscribe to my channel and be alerted to future new videos that I upload weekly. Thanks for watching.